lucky to have Denise Robertson. She is an associate at Mills and Mills. Her year of call is 2005. As you can see, here's her contact information, and even get to see what and who she is, so really great. She's on many different memberships and affiliations. She's a strong believer in small business and a huge advocate. So I would love to now present Denise and hand the floor over to you.
Thank you, Carla, and thank you for inviting me to speak today. Good morning, everyone. As Carla mentioned, I'm a lawyer with the law firm Mills and Mills LLP. The area that I practice in is corporate and commercial, working with privately owned businesses on a variety of different legal issues. This might include contract drafting and review, preparing the contract based on the client's instructions, or maybe it's just reviewing it over the phone for about an hour or so to make sure that my clients understand what they're signing before they sign it. I also deal with business formation, including incorporations, partnerships, or setting up sole proprietorships. Also do the shareholders agreements that sometimes go along with the incorporations. Often warn people that a shareholder relationship or a partnership relationship is like a marriage, and it's important to know what you're getting into, and sometimes more important to know how you're going to get out of it. I also handle independent contractor and employment agreements, and then finally estate planning. After putting so much effort into creating and building a business, I work with clients to protect all of it in the event that they are incapable or that they pass on. My firm is located at Yonge and St. Clair, and as a full-service law firm, I have access to legal assistance in a variety of other areas, including real estate, family, intellectual property, litigation, and estates. So after a brief introduction about risk, I will be reviewing top 7 legal issues faced by small business owners. And you'll see on the slide there, we've got business structures, working with others, contracts and written agreements, protection of intellectual property, premises, general liability, and finally estate planning. There are, of course, a number of other issues that small business owners face, please note that my discussion today is just a general overview of these top 7 and should not be considered to be legal advice for any specific scenario. So if we go to the next slide, it is important to properly address legal issues in a timely manner, as it can help you to minimize legal and business risk. There are 3 main risks to you and your business if you are faced with a legal claim or some form of complaint. First would be financial. If there is a judgment against you in a civil action, you will have to pay it, plus possibly legal fees in defending the claim. Second would be your time. Dealing with legal claims and other complaints can be time-consuming and a major distraction. The time you spend defending yourself and preparing for the court proceeding would be better spent on your business. Loss of time also has a financial impact, as we all know. And finally, and perhaps the most significant risk, could be the impact on reputation. As a business owner and professional, your reputation is all you really have. Aside from earning and collecting money, it is crucial to protect your reputation in order for your business to survive. Other ways you may be exposed to risk are generally sector-specific, to what area of business you are in. All risks can be costly with respect to time, distraction, and money out of pocket. These are the types of risks that you can attempt to minimize by addressing the top 7 legal concerns of small business owners. So let's begin. We look first at corporate structure, what your business structure is. This is one of most important decisions in the early stages of a new business, or as a business grows and is choosing the proper business structure going forward, because things change as your business gets bigger. The business structure you choose not only impacts liability, taxes, and reporting for your business, but it may also have a significant impact in the execution of a business strategy. It is never too early to establish your business plan and choose your business structure. There are 2 basic forms of business organization available in Ontario. The first is unincorporated business, which may be either sole proprietorship, and this is a business owned by one person. This is often how many businesses start out. The owner has complete control over the business and receives all of the profits, but the owner is also personally liable for all of the debts and liabilities of that business, and such liability extends even to personal property and assets. For example, the owner's home. The other form of unincorporated business is a partnership. The difference is that there's two or more owners, or we call them partners. Each partner is jointly and severally liable for the debts of the partnership. It is crucial that you know what your partner is doing and how he or she is committing the company. For this structure, a partnership agreement is very important as it defines the management responsibilities, cash obligations, interest in the business, allocation of profits for each partner, and how the partnership can be terminated. The second form of business organization is a corporation. This is a separate and distinct legal entity. Ownership of a corporation is through the ownership of shares in its capital stock, and shareholders are not responsible for the corporation's debts. For example, a shareholder's house is not available to the corporation's creditors. Let's review the advantages and disadvantages of a sole proprietorship and a corporation. Sole proprietorship is the easiest and least expensive to organize. It's all you, but it has the highest exposure for personal liability. Some of the advantages are listed on the slides, as you'll see. Easy and inexpensive to form a sole proprietorship. You will only need to register your business name provincially. Relatively low cost to start up the business. Lowest amount of ongoing regulatory burden. You have direct control of decision making, minimal working capital required to start up, and you can possibly take advantage of certain tax advantages if the business is not doing well. For example, deducting your losses from your personal income, and you'll be in a lower tax bracket when profits are low, and so on. And all profits will go to you directly. But some of the disadvantages with a sole proprietorship on the next slide outline the fact that it is unlimited liability. If you have business debts, personal assets would be used to pay off that debt. Remember, this goes back to your own home that you might own or other assets that you have going to pay off the business debts. Income is taxable at your personal rate, and if your business is profitable, this may put you in a higher tax bracket than you would be in if you were incorporated. There's a lack of continuity for your business if, for example, you need to be absent for one reason or another. Sometimes third parties may not want to work with an unincorporated business. There's fewer income tax deferral opportunities on income retained in the business, and you might have some difficulty raising capital on your own. Although a corporation may seem to be the most complex organization, there is flexibility because you can do it alone or with others who are active in the business or silent shareholders, the investors in your business. Some of the advantages of incorporation include limited liability. You are not personally liable for the debts of the corporation. Remember, the corporation is a separate and distinct legal entity from you. Also, ownership is transferable. Owners can put a shareholders agreement in place to set out how the corporation will be managed and how they can exit. There's a continuous existence of the corporation, so even if something happens to you, the other shareholders can carry on with the business, or your family members may carry on with the business. It still exists. And it can be easier to raise capital. This may be through investors investing in the business or by way of government grants for small businesses that need to be incorporated in order to get those grants. There's also possible tax advantages, as tax may be lower for incorporated business, and you can take advantage of the use of holding companies if you develop a more complex corporate structure. All of that, of course, comes with accounting and tax advice. Finally, you can incorporate at the federal or provincial level. So you can have an Ontario company or a Canadian company. There are some disadvantages with incorporation as well. These are on the next slide, and you'll see corporation is closely regulated. What I mean by this is that there are filing requirements, of course, to file a second income tax return with the CRA. These are not overly cumbersome, but it is a difference from a sole proprietorship. It can be more expensive to incorporate than set up a sole proprietorship or a partnership. However, oftentimes the negotiation of a partnership agreement can be more costly than incorporating a company with one director and one shareholder. For corporations, corporate records are required. This includes having shareholder and directors meetings. You may not meet in person, but it could be simply signing off on resolutions. And you have to have, of course, documentation filed annually with the government. There's also the possibility of conflict between shareholders and directors. Possible problem with residency of directors if they're in another province or the majority are not Canadian. Overall, your profession, tax implications, your reason for starting your business, whether you're going it alone or with someone else, risks of liability, and your personal, professional, and financial goals will largely determine the type of business organization you choose. I also recommend that you speak with an accountant about the business structure before you finalize the plan. So the next main issue is working with others. There are a variety of ways that business owners might work with others. The most common way is with employees and independent contractors. Hiring employees and retaining the services of independent contractors is a very exciting time because it means your company is growing. From time to time, you may also be hired as an independent contractor to provide services. As a result, this topic may have important implications for you in two different capacities. Is your independent contractor actually an employee? If this question sends shivers down your spine at tax time, you're not alone. The difference between an employment relationship and a business relationship is not cut and dry. And having the CRA determine that you have an employee after all can have very expensive repercussions for both you and your employee. Employers do like to retain independent contractors. Hiring a contractor means a lot less rigmarole than hiring an employee and can be a lot less expensive too. Contractors don't get benefit packages or pensions, and they pay their own CPP contributions. If you retain an independent contractor, you don't have to withhold income tax or pay a share of the CPP or EI. And of course, the big tax advantages for the independent contractor is the potential for tax deductions. Generally, a self-employed person can deduct all reasonable business expenses. Sounds great, doesn't it? But if a business hires a contractor who is later deemed to be an employee, both parties lose big as unpaid taxes, penalties, interest, CPP, and EI premiums will all have to be paid. Because the employee relationship and the business relationship is one of those areas that's constantly in flux, it's important to do what you can to protect the relationship status. First, you need to be aware of the four-part test that the CRA uses to determine which type of relationship exists. The test is based on 4 key points which I've outlined in the slides. First, control. Who's running the ship? Who's in control of the business? Second, ownership of tools. Third, chance of profit, risk of loss. And finally, integration into the business. It would seem to me that one obvious way of proving integration into your own commercial activities would be to have multiple clients. The contractor who has only one client makes it too easy for others to perceive his relationship with that client as an employment one. Also, to protect yourself, whether you're wearing your contractor hat or your employer hat, you should always enshrine your relationship in a contract. Some businesses say they hire consultants and try to get around identifying them as employees through an agreement that does not accurately reflect the true working relationship. If it walks like a duck and quacks like a duck, it's a duck, regardless of what you might call it and how you might describe it in a contract. Hiring employees can also mean firing employees, and this is not always an easy thing to do. You should know your legal obligations before hiring or firing an employee. If you don't have an employment agreement, hiring an employee can be very expensive. So as your business grows and as you take on employees, be sure to have a letter of employment in place with each one to minimize potential future expenses. Another way that you might work with others is through a joint venture. It's a strategic alliance between 2 or more individuals or entities to engage in specific project or undertaking. The necessary elements of a joint venture are an express or implied agreement, a common purpose that the group intends to carry out, shared profits and losses, and each member's equal voice in controlling the project. Once the joint venture has met its goals, it will no longer exist. When embarking on a joint venture, it's imperative to have your understanding in writing. You should set out the terms and conditions agreed upon in a written contract. This will prevent misunderstandings and provide both parties with strong legal recourse in the event the other party fails to fulfill its obligations while under contract. Now we'll move on to the next legal concern: contracts and written agreements. You may recognize the recurring theme in my talk so far: get it in writing. So we can make our motto for today, and hopefully for your business every day following: if it's not in writing, it doesn't exist. The most important reasons for having a contract in place are to ensure that both you and the other party have the same expectations and that clarity is achieved in the working relationship. It also provides the opportunity to clarify and confirm the scope of services, fees, and any other issues. Now, negotiating contracts can be intimidating and difficult. People often feel that if they press too much for a contract or if they ask for specific terms or clauses, a potential client might be turned off. What you must always remember is that working with contracts is the professional way to do things. Anyone who balks at formalizing the terms of an engagement with a letter or a contract is not acting in a professional manner. No matter how much you want a particular client or job, if the people involved refuse to sign an agreement or take issue with the terms that are important to your business, you should take it as a red flag and strongly consider walking away. If you don't, chances are you may regret it later. And entering into a written agreement doesn't necessarily mean a cumbersome 40-plus page contract full of legalese. The contract should suit the project. So it could be a short-term consulting contract worth $5,000, may only require a 3 to 4 page letter. And a letter is just as binding as a contract, provided it's signed off on by both parties. I'm going to highlight some provisions that generally are included in an agreement, and I'll use a services agreement as an example. The first one is the proper identification of parties. If your company is incorporated, the agreement must be in the name of the company and not your name personally, to make sure you maintain your limited liability. It is also important that your client be properly identified. The next item is scope of services and additional services. The scope of services is the provision that describes the specific work you are going to complete. The scope must be clearly defined and detailed what you are committing to. And as we all know, things change. During the working relationship with your client, the service you are supplying may be amended or the client may request additional services. Ideally, I like to see this in a revised agreement, but I understand this is not always practical. At a minimum, send an email confirming any conversation regarding changes and ask the client to confirm by reply email. And always take notes, lots of notes, because as the motto goes, if it's not in writing, it doesn't exist. The third item in written agreements is the pricing structure. Very important to the business owner. There are a variety of ways that you can charge for services. Common ones include a flat fee or an hourly rate, or some form of a combined flat fee and hourly rate. A good approach to dealing with fees is to obtain an initial deposit from the client when the agreement is signed. The retainer or deposit can be held by you until the contract is complete, and then it can be applied to your final invoice. You should generally invoice regularly. By doing so, you can identify any payment issues early on, and the client is not surprised by the cost of the services, especially where the billing method is by hourly rate. The agreement should also outline who is responsible for the payment of certain expenses and other disbursements, state whether HST is payable, and state whether there is interest on any outstanding accounts. The next item is client responsibilities. You may have to rely on information provided or actions taken by the client or a third party. If there is crucial information that the client is to provide or crucial actions that the client or a third party is to take, they should be specifically outlined in the agreement. And then next we have representations and warranties. Representations and warranties should be limited to what is in your control and to what you know to be true. You should not make any representations or warranties about the quality or timeliness of work conducted by other parties, for example. If there's a delay or a defect or an incompetence by somebody else, the client should look to that person for legal remedy and not you. The last 5 items in a written agreement are on the next slide. First one being independent contractors. We talked a little bit about this already, but when your role is one of consultant, it's important that the agreement with your client also states that you're an independent contractor retained by the client to provide services and not an employee of the client. Make it clear that the agreement is not exclusive and you have ongoing work for other clients as well. Another important provision in agreements is the termination and possible suspension of the agreement. In order to protect both you and your client, your agreement should have provisions describing how the agreement may be terminated or suspended. For example, an agreement may be terminated if the client fails to pay you, or you fail to perform services, or either party becomes bankrupt. You should also include a detailed description of what happens on termination. Most important being that you render your final invoice for unbilled fees and expenses, and the client is to pay within a certain period of time. And from time to time, clients change their minds about services, run out of funds, or simply need to delay. And in these circumstances, the services may need to be suspended for a particular time, and you might want to put some parameters around how they can start the services running again. Another important provision in a contract is the insurance and liability. Agreements may specifically state the amount of insurance to be carried by you, but they should also provide, though, if there's any additional insurance required by the client, that it be the client's responsibility to get that insurance. And to further protect you, agreements can also include a statement limiting liability. For example, now this is the one we get into some of the legalese, but I'll go easy on you. So for example, the client agrees to release the consultant from any and all liability that the consultant may have to the client for any amount in excess of the fees paid by the client to the consultant, or the amount payable under the consultant's insurance policy, whichever is less. This provision may prevent the client from being able to sue the consultant for more than what the client has actually paid under the agreement. But the release may not be enforceable if you've been negligent or fraudulent in the performance of your services. Another important item in certain sectors is the ownership of intellectual property. Unless you and the client have agreed otherwise, copyright and works created for the client by you belong to you. You should always mark your work accordingly. If copyright is an important issue for your business, and in order to avoid any claims in copyright by the client in the future, it is important that the ownership of the copyright be clearly stated in the agreement. This is often an issue that can be missed and come up later on in a dispute. And then finally, disputes. Dispute resolution. Often the best dispute resolution provisions included in an agreement is one that describes an escalating process, negotiation through to mediation, and then gives you and the client the option to pursue remedy in the appropriate forum. And finally, if I was sitting on the other side of the table representing your clients, I would possibly suggest a confidentiality provision, an exclusivity provision. For example, you can't work for any of my clients' competitors, and perhaps a termination on notice provision so they can get out of the agreement after simply just giving a certain amount of notice. We move on now to the next legal concern, intellectual property. I've mentioned intellectual property, mainly copyright already, and I would like to take some time to discuss it and others in more detail. Intellectual property, the goodwill of your business, is an important consideration as you grow your business. IP is only worth something when your business is worth something, or what you've created is worth something. It is up to you to protect your business and yourself. There are certain things that you can do up front, and they cost very little in comparison to what failing to do them could cost you in the future. For example, if you're a sole proprietor, just be sure to register your business name It's a simple process. It can be done online, but you must be warned that a business name registration lasts only for 5 years, so you must be sure to renew it. For unregistered copyrighted work or publications that you want to protect, add a C together with your name and the date at the bottom. You'll see an example in the slide. And on the next slide, if you have an unregistered trademark, you just put a little TM beside it. And then once you register that trademark, you can change the TM to the R in a circle. You probably see this on various products. And back to the motto, always have written agreements. Again, these need be complex or fancy, but should cover the significant issues. And when there is intellectual property involved, copyright, licenses, and work product, for example, you need to be specific about who has the rights to what. And my most important comment about intellectual property is that if you are seeking help or input from others, or you're making a pitch to another business, be sure to protect your ideas, your business plans, your methodology, and your work in progress with a confidentiality and non-disclosure agreement from the outset. And the general rule in copyright is that the creator of the work owns the work. But as with most rules, there are some exceptions to the general rule and situations where it's not applicable. Be sure to always have these types of clauses in writing. The next issue is premises. As I'm sure you all know, real estate for your business is expensive. Purchasing or leasing space may be the single most significant liability for many businesses, and it is important to understand all of your legal obligations. If you own your office, zoning and insurance are likely your biggest concerns. If you're running your business out of your home, it's important to obtain tax advice to take advantage of any write-offs and to ensure you're not actually writing off too much. Now, the majority of small business owners, however, lease their space. Make sure the term of the lease and the renewals are adequate for your business needs. You don't want to start a business in a certain location, complete a number of leasehold improvements, start to build up on some goodwill, and then have to move. Be aware that rent is not always all-inclusive, and you have to be careful to understand what is included in additional rent, common expenses, or adjustments. And if you have an incorporated business, it is not uncommon for a landlord to still require you to personally guarantee a lease. I recommend against this if at all possible, but oftentimes it's a deal breaker for a landlord. And be sure to watch out for insurance provisions in leases. Sometimes a lease will include a requirement that the tenant obtain a $5 million general liability insurance policy, for example, but the tenant's insurance provider only recommends about $2 million. These types of provisions are generally negotiable but can be overlooked. When a business has leased premises that turn out to be too large for their needs, a good option is to sublease or to sublet part of the space. Be sure to review your lease agreement before doing so, because 99% of the time you will need your landlord's consent. Finally, including assignment rights in a lease are also important. If you sell your business or you wish to move, you may need to assign the lease to a third party, so those rights should be contained in the agreement. Now, the next issue is your general liability. The good news first, overall, there's very few business owners who are sued successfully. But things do go wrong in every business, and it may be important to have insurance in place. I've talked a little bit about insurance already, but I want to say that you should be sure to speak with your insurance broker about everything from general liability insurance to errors and omissions liability insurance, business interruption insurance, and whatever else they may suggest. There are generally two ways that a business can be sued. First, breach of contract, and second, in tort law. And there are two types of legal proceedings you may face. The first type are legal claims brought by disgruntled clients, suppliers, competitors. These would all be in court situations. Your potential liability under contract law includes deficiencies in services. You haven't delivered what you said you were going to deliver, or there was actual negligence. And your potential liability in tort, if it can be shown that your improper action injured a third party, you may be liable. There must be proof of loss, harm, or damage for the tort case to proceed. An unintentional tort can occur because of an error or omission. It may be a complete mistake, inexperience, or miscommunication, but you still may get entangled in a court proceeding. To be successful in tort, a plaintiff must prove 1. A duty of care existed, that there is a responsibility to avoid careless acts which could harm others. 2. That a standard of care existed, the standard by which reasonableness is determined. 3. The standard of care was breached, proof that you did not meet the standard of care. And then finally, 4. Causation. There was a relationship between your unreasonable actions and the plaintiff's loss or harm. Causation involves proving that the accident or injury would not have occurred but for your unreasonable actions. Now, on the next slide, you'll see that you may also be liable for the work of others. For example, employees. Employers are generally liable for the work of their employees, or subcontractors and independent contractors. This will be subject to what's in your written agreement. And then with partners and joint venturers, any loss to the business may also be a loss to you personally, financial, reputation. And regardless of how liability flows, an angry client or someone who is injured is likely to sue everyone involved. So a good defense always goes back to the quality of your documentation. And the second type of legal proceeding you may face is a regulatory action. These are sector-specific and may include a loss of business license being reported to Ontario Health and Safety Board, or if you're a regulated professional being complained about to your provincial association and facing discipline proceedings. So finally, the last issue to discuss today is estate planning. I've discussed a number of issues you may face in setting up and running your business. You will be investing a lot of time and a lot of money into it and hopefully making a good return. But you also need to consider what you want to do with your assets. Wills and powers of attorney are not only vital once you have assets or a family, but are also strongly recommended for business owners and professionals. There are two different types of powers of attorney. One for property, dealing with your finances, and one for personal care, dealing with your care and treatment decisions. This has also been referred to as a living will that you may have heard of. Powers of attorney come into effect when you are alive but not capable of handling your own financial affairs or making your own healthcare decisions. Properly completing your estate plan, setting out who the estate trustees, any legacies you want to give, cash legacies, what happens with everything else that's left over after the taxes and funeral expenses are all paid, and if you have young children, who's appointed as the guardians. So properly completing your estate plan can result in less tax to your estate, less hassle and cost for your loved ones and business partners, greater clarity in your business succession plans, and help some people sleep a little bit better at night. On the next slide, you'll see that owners of shares in privately held corporations can prepare what's called primary and secondary wills in order to minimize probate tax. A primary will deals with the assets that need to be probated, while all assets that do not need to go through probate, including shares in your corporation, are dealt with in the secondary will. So if the shares of your privately held corporation are worth, say, $500,000 at the time of your death, your estate will not have to pay probate tax on that amount. You will want to ensure that your wishes are met, and the only way to do so is to set them out in writing. So remember the motto. And estate planning is probably the least expensive and least time-consuming item I've discussed today, but it is often the most overlooked. Today's discussion was not meant to deter you from the business world, but to help you recognize legal issues and learn ways to minimize your business and legal risk. I will leave you with a concluding thought. Practice healthy skepticism and don't trust too much, especially when there is money on the table. Remember that if you don't protect your interests, nobody else will. And it was a pleasure speaking with you all today. I believe my contact information has been provided to you. If you have any questions or would like more information about any of these issues, please send me an email or feel free to give me a call. Thank you.